Hi everyone, and welcome to this afternoon presentation by Sovereign Trust and myself, Peter Feinbash. Just by way of introduction, I'm a consultant of the Hong Kong office of Sovereign Trust, specialist in trust and estate planning, and step qualified TEP. Just a bit of housekeeping first and foremost. This webinar is being recorded and you'll receive a copy in around 24 hours via email. If anyone has any questions, feel free to type them into the box on the dashboard, and I'll do my best to answer all questions at the end. And if we run out of time, I'll get in touch directly after the webinar, or perhaps in the next 24 hours. My colleague Winnie Chirk did a similar webinar this morning, or in fact on the same subject, but in Cantonese. So if anyone would like to listen to it in Cantonese, please let either myself or Winnie know, and we can send that off to you. Just a quick introduction about Sovereign. So Sovereign is a licensed trust and corporate service provider. We offer an array of services across 4 key areas, which are corporate services, private client services, retirement planning, and insurance services. One of the key areas of our business is the setup and the management of trusts and underlying companies. If we're not we don't provide, this is not a tax seminar per se, so please don't take this as tax or legal or life advice, which you are advised to do independently. But it's a good illustration of some of the key issues, certainly for someone looking to move to the UK for the first time, and some of the solutions that we have provided. So it's an overview. We can do the tax part in-house by one of my colleagues, but this is not a bespoke tax webinar by any means. Just a bit more information about Sovereign. So we've been around for over 35 years. We were incorporated or started in 1987 in Gibraltar, where we are still headquartered, and we've been in Hong Kong since 1989. Hong Kong has always been one of our key markets and remains one of the key offices across the group. We've got offices in over 20 jurisdictions, as far-reaching as South Africa, Cyprus, Hong Kong, Singapore, and of course the UK. 9 trust licenses, so we license trust providers in 9 jurisdictions, the UK, Malta, and Cyprus, which we would consider onshore, Singapore, Mauritius, and Hong Kong, which we would consider midshore, and Isle of Man, Guernsey, and Gibraltar, which are the true offshore jurisdictions. So remember, the main focus of this webinar is really on moving to the UK for the first time. So those of you using perhaps the BNP Visa or BNP passport to move to the UK, it's not really aimed at Brits that have lived in Hong Kong or overseas for an amount of time and are considering moving back to the UK. That's a different beast. But some of the key concepts might nonetheless apply to you anyway. So what we're going to cover today is just a brief introduction about domicile, what it is, and what your status might be. A very brief overview of the UK tax landscape, and in particular the 3 key areas that might apply to you, including inheritance tax, capital gains, and income, and the rates. We'll focus a little bit more on the inheritance tax position or an inheritance tax. We'll talk about what a trust is and an excluded property trust, which is a tool that can be used to mitigate your inheritance tax liability, and we'll go through the procedures. So again, a reminder, this webinar is really aimed at Hong Kongers moving to the UK for the first time, and this should not be constituted as advice. So why are we doing this? So there's been a very big interest in the BNO scheme, And it's imperative that you get your financial affairs in order before you move to the UK. And it's important to make an informed decision and to plan accordingly. So it's a very, UK tax is a vast area, and this is just intended to be a simple overview. Please do speak to us because every person's circumstances are always different. The BNO visa scheme essentially allows successful applicants to live, work, and study in the UK for up to 5 years, and then apply to citizenship after 6. So it's a path to citizenship. It's available to BNOs, their family members, including spouses, children, cohabiting parents, unmarried partners, etc. So it's open to a lot of Hong Kongers. So it's a sheer numbers game, and it's actually a huge opportunity for the UK revenue to fill their coffers. So you really, really should do some planning. So I'll cover domicile, and this is a good starting point because it's important to understand, because domicile affects how you're going to be treated. It affects your income tax position, inheritance tax, and CGT. It's an important concept as it affects each and every individual with a UK connection. It's a common law concept, which means that it's not codified under UK law. It's a concept that's built up over time and interpreted by courts, HMRC, legal scholars, etc. Very basically, it's where one considers their long-term permanent home. So it's actually, when I say consider, it's actually a completely subjective thing. It's all about your feelings. So it doesn't necessarily depend on where your citizenship, where you're a citizen of, or where you're a resident. It's possible to have a domicile in a country that you've never visited. So there's 3 main domiciles to consider, or types of domicile. So everyone would acquire a domicile of origin. So this is the domicile that you acquire at birth and is your default domicile throughout your life. So if later in life your domicile cannot be determined, you will actually revert back to your domicile of origin, which is something you acquire at birth. It's not necessarily where you were born, so you typically would acquire your domicile from your father. So when you're born, you take up your father's domicile. So you might be born in Hong Kong to British parents, for example, then you'd be considered to have a domicile of origin in Britain or the UK. You can also have a domicile of dependency, which is essentially if your parents' domicile changes before you reach the age of 16 or 18, it can depend. It depends. Your domicile you can actually acquire a domicile of dependency. So if perhaps you were born to a UK domicile father that became domiciled in Hong Kong before you reached the age of 16, before you reach the age of 16, you would acquire that domicile of dependency. And then lastly, there's a domicile of choice. So as I said, it's all about your feelings. So someone can change their domicile of origin by taking up a domicile of choice. And that's essentially if you move to another jurisdiction with the intention of remaining there permanently. So it's, again, it's extremely subjective. So if you move to Hong Kong with the intention of from the UK with the intention of never going back, it is possible to acquire a domicile of choice. It's not easy, but it can be done. Many Brits that have moved away would argue that they are domiciled outside of the UK, having taken up domicile of choice elsewhere. This will be contested and often is by HMRC. So everyone has a domicile, but only one. There's another form of domicile actually, and that's deemed domicile, which is kind of key to this presentation. So anyone that moves to the UK will be deemed to be UK domiciled after 15 out of 20 tax years, even if your subjective intention is not to remain there permanently. So as a Hong Konger moving to the UK, you might consider yourself there temporarily, for a few years. Even after year 16, you still consider yourself Hong Konger and aim to come back to Hong Kong. As far as the law is concerned in the UK, you'll be treated, or you'll be deemed to have a UK domicile, and you'll be taxed accordingly as if you were domiciled in the UK. So it's easy to get caught out, so one must be a little bit careful. So am I UK domiciled? This is a good question to ask yourself before moving to the UK. I'm just going to give you an example of a typical Hong Konger that might be moving to the UK on the BNO scheme. So we've got Jay and Rebecca Chan, with 2 children. They're BNO passport holders, or they might be moving on through a BNO visa, all born in Hong Kong and have lived here since birth. Their parents are living in Hong Kong. They would be considered non-dom, based just on these facts alone, despite holding BNO passports. So it's a pretty safe assumption to make. Sorry about that. But even if they're planning on living, working in UK, the starting point is they would be non-dom. Be careful, as they might be deemed domiciled after 15 years. So even if they do intend just to stay in the UK temporarily and they stay for 15 years, they might be domiciled sooner. The effect of being domiciled in the UK and resident there is all overseas assets, and including UK assets, will be subject to income, capital gains, and inheritance tax. There is an argument, if they take up this indefinite leave to remain, or if they apply to citizenship, they might even be domiciled in the UK before 15 years. So that's another topic of discussion, but there is a trap, there's a potential trap there, because essentially you're taking on permanent residence. So you're saying to the UK, you're becoming a citizen and you're staying there permanently. So just be wary of that trap as well. So why should you care about domicile? Well, as I've mentioned before, it affects your inheritance tax, capital gains tax, and income tax. The default position for someone that is non-resident and non-dom is that overseas assets obviously are not taxable. So if you're not resident in the UK and you're not domiciled there, only assets that you might have in the UK are subject to tax in the UK. So if you've got a UK property, for example, or UK investments sat in the UK, or even your property, those will be taxable for income, capital gains, and inheritance tax. They're only UK assets. So if you don't have any UK assets, no tax. If you become UK resident, so if you move to the UK and are non-dom, like your typical BNO, the UK has you actually are taxable for your worldwide income and gains. So I'll get to that on the next slide, but basically the UK tax on an arising basis, which is essentially tax on your worldwide estate. So you'll be subject to income tax on UK and non-UK assets, capital gains tax. Importantly, inheritance tax will only be taxable on your UK assets, provided you are non-dom. There is the ability to pay not to be taxed on your overseas income and gains, as if you claim the remittance basis, which I'll get into in a minute. So essentially, you can pay to claim the remittance basis, and then you will only pay income and gains on assets or income and gains that you remit to the UK. If you are a UK resident domiciled, you're subject to income gains and inheritance tax on UK and non-UK assets. That's also if you're deemed UK domiciled after 15 years. So what are the difference in tax rates? So essentially, Hong Kong has a territorial system of taxation. So income, capital gains, and inheritance tax do not apply. In fact, on worldwide on assets. Whereas in the UK, you tax on an arising basis, which means worldwide tax on income and gains, on an arising basis, as opposed to the remittance basis, where you're only taxed on overseas income and gains if you remit that to the UK. There's three basic, there's a progressive rate on both income and capital gains tax, and inheritance tax is a fixed rate of 40% tax over the nil rate band, which I'll get into a little bit further on. So just a little bit more about the remittance basis. So again, default position, residents in the UK liable to worldwide tax on income and gains. So that's it. There is a choice or an alternative tax treatment available to resident non-DOMs that have foreign income and gains, and that's a remittance basis, which essentially means you elect to only pay income and gains on assets that you remit into the UK. Now, this comes at a cost. First and foremost, you lose your personal allowance. So, and this is over any number of years, and you can only do this for a certain amount of years. So for the first 7 years, there's no cost besides the loss of your personal allowance. After 7 years, so from 8 to 10 years, you actually have to pay £30,000 per annum to the revenue to be able to enjoy the remittance basis of taxation. That increases to £60,000 after 13 years, and after 15 years, the remittance basis is not available, and no matter what, is subject to pay tax on your income and gains. So there's a few extra bits here. So basically, if your overseas income and gains is under £2,000, then the remittance basis is essentially automatic, so you don't need to claim it. But you should always speak to a tax advisor who can look at your circumstances, do the calculations, and see whether it's worth your while to lose your allowance, claim the remittance basis or not, and what the effects would be. Remember, this is something that's not automatic. It's something that needs to be claimed on your tax return. This is just an example of something that you might remember from the news recently, and it was a big subject of media attention a couple of months ago, or in April, when Rishi Sunak's wife, who's the Chancellor of the Exchequer, it was found out, or it was revealed to the media, that she was paying the remittance basis of taxation. So his wife, Mrs. Sunak, receives around £11.5 million from her family business. She's the heir of Infosys. She is a non-DOM for tax purposes, and did perfectly legitimately claim the remittance basis of taxation. I think she was at the time paying £30,000, so she would have been in year 7 or above, which would mean she would only pay income and gains on tax that she remits income that she remits to the UK. However, because of her husband's position and due to public pressure, she actually decided to stop claiming the remittance basis and pay tax on her worldwide income and gains. So she bowed to public pressure in this case, even though it was a perfectly legitimate and long-standing tax method of assessing tax. So all I'm trying to say here is, yes, she relied on a remittance basis, but if she had an offshore trust in place, the result for her might have been very different. And I'll get into how a trust could have worked for her in the next couple of slides. Next up, inheritance tax. So I'll put income and gains to the side for a minute and just talk about inheritance tax. And this will be the main continued focus for this presentation. Why? It's probably the single most or biggest chunk of tax that people have to pay, and the one most people have the biggest issue with. You pay tax in your entire life and then have to pay it again when you die. At a very basic level, if you're UK domiciled, you have to pay tax on your worldwide estates. So that means 40% on all your UK as well as your non-UK assets. Remember, if you're non-dom, you only pay tax, again, at 40% on your UK assets. every person has a £325,000 nil rate band, which is essentially the tax-free amount. So your first £325,000 is tax-free. Anything you have over that amount will be taxed at 40%. You do get a number of exemptions and reliefs. I will go through some of them in the next slide. But yeah, it's a big chunk. The first exemption, which is probably the most common, is the spousal exemption, which essentially means there's no tax between spouses. So if someone passes away and they're married, you can give everything to your spouse without tax, and anything so anything to someone that you give to someone else over £325,000 will be subject to tax. So there's no tax between spouses, which means you can roll over the tax until second death. So it's only when the second spouse passes away before giving assets to other people when the tax comes in. So you essentially get a combined £650,000 tax-free allowance. There are some caveats and exceptions there. So the spouses need to have the same domicile. There are issues if one spouse might be domiciled in Hong Kong and the other in the UK, but we can work with that. But as a starting point, there's no tax between spouses. The second exemption is for the family home. So everyone gets an additional £175,000 for your personal residence. You have to have lived in the house at some point. So what this essentially means is that a married couple gets £350,000, so 2 times 175, plus £650,000 tax-free. So essentially £1 million. Another caveat here is if your overall estate is over £2 million, then that additional allowance for the family home does fall away gradually. And I won't get into the numbers, but it does fall away. So there's only a certain band that this is available for. Gifts to charity are also inheritance tax exempt. So anything you give to charity is tax-free. So this encourages people to make charitable bequests through their wills. If you bequest over 36% of your overall estate, again, subject to exemptions, but basically if you gift over 36%, my mistake, if you gift over 10% of your estate, the rate of tax reduces from 40% to 36%. So you are incentivized to gift as much as you can to charity. There's also certain reliefs for certain qualifying businesses. So if you've got a qualifying business, it might not be subject to inheritance tax. You could get a full 100% relief on that business. If you've got a certain agricultural property or business, you might receive 50% relief. And the most important one for this conversation is anything in trust. So there's no tax on, well, I shouldn't say there's no tax on trusts, but because any assets in trust fall outside of your estate for inheritance tax purposes, those do not form part of your taxable estate. However, importantly, if you're UK domiciled, there is a charge to IHT for setting up the trust. So trust planning doesn't really work for UK domiciled individuals. There might be a 20% tax on entry or on setup. There might be an anniversary charge every 10 years. The overall value of whatever's in trust might be chargeable to inheritance tax at around 6%. And there's also exit charges. So this gives a non-dom Hong Konger a far bigger advantage over someone that might be domiciled in the UK, because a Hong Konger can set up the trusts tax-free and it'll fall outside of their taxable estate for inheritance tax purposes. So just a quick summary of the differences between the tax treatment on certain assets between a UK domiciled individual and a non-dom. If you have a Hong Kong bank account and you're UK domiciled, it would be subject to UK inheritance tax. It will form part of your taxable estate. If you're non-dom, it will be exempt. BVI overseas company, again, non-dom exempt, UK dom subject to IHT. Hong Kong apartment, once you become domiciled in the UK, it forms part of your taxable estate. If you're non-dom, you're exempt. So after 15 years, your Hong Kong properties will be subject to UK inheritance tax. Another form of planning that you can do is pension planning. So pensions, SIPs, or some other types of pensions, UNAPs, for example, which we can do as well, and that's a different discussion, are also exempt for both UK DOMs and non-DOMs. So pension planning is quite common, certainly for someone that's domiciled in the UK. UK residential property, regardless of whether you're domiciled or non-domiciled, it will always be subject to UK inheritance tax. So that's just a quick comparison. I'm going to talk about trusts now, just move along a bit, and then talk about how trusts work and how they, why they shield against inheritance tax. So what is a trust? So a trust is essentially a relationship between three parties. You get the settlor on the one hand, which is the person, client, you want to call him, the person setting up the trust. It's the person, it's the original owner putting assets into the trust. The second party is the trustee, who receives assets and looks after the assets on behalf of the beneficiaries. So receives assets from the settlor, looks after the assets on behalf of the beneficiaries. The settlor transfers legal title, so he actually transfers those assets to the name of the trustee, who becomes the owner of the assets. It's not full ownership though, because there's a third party or in this triangle, and that's the beneficiaries. It could be the spouse, could be the settlor, could be a charity, it could be a third party. But this triangle creates the trust, this relationship between the three parties. The trustee promises to look after the assets on behalf of the beneficiaries. So the trustee cannot benefit from the assets. So there's a separation between legal ownership, so the assets on the trustee's name, and beneficial ownership in terms of who can benefit. The trustee owes a duty to the beneficiaries, a duty of care, a fiduciary duty, and has to act in the best interests of the beneficiaries as a whole. So it's a relationship between these three parties. It's not a legal entity in itself. This is just an example of what a trust might look like, or a typical family trust for a Hong Kong family. So you get the settlor setting up the Hong X family trust for the benefit of herself, Mrs. X, her husband, and her children. Very simple. Sovereign trustees have been appointed as professional trustees, and they take legal title of the assets. Beneficial title belongs to the beneficiaries. You normally create a trust through a trust instrument or a trust deed, which sets out the rights and responsibilities of the trustees and the mechanics of how it's all going to work. You might have a letter of wishes, it's highly recommended, which basically guides the trustees on how you would like the assets and trusts to be dealt with. This is particularly important if the settlor passes away. The trust will continue to exist, and the trustees will be guided by the letter of wishes in terms of when to make distributions, how to deal with assets, etc., etc. The trust then might typically have a holding company underneath, whether in Hong Kong or elsewhere. The holding company will in turn own cash, investments, bank account, brokerage account, etc. The trust can also hold assets directly, so it can have its own bank account, it can own a residential property, it can own insurance policies. There's a wide array of assets that a trust can own. You might appoint a protector, which is an independent third party with the ability to hire and fire trustees, or you might give them other powers. It just depends on your circumstances and the advice you're given. Typically, you might appoint an independent asset manager to manage the assets. The settlor can have some control over the assets as well. I'll talk about that in a minute. But this is your typical structure. Again, the key principles of trust is that it's a relationship, so it's not a legal entity in itself. What does that mean? It means that the trustee doesn't have a legal personality. It cannot enter into contract. It's the trustee that enters into contract on behalf of the trust itself. The trustee can be sued, the trust can't. And assets are kept separate from the trustee. They're ring-fenced. The trustee owns a duty of care to the beneficiaries, which is very, very important. So that's just a key principle. Quickly, just the main advantages of setting up a trust, besides the tax that I'm going to get into in a minute. Number one would be asset protection. So trusts offer protection in the event of creditors, for example, divorce. And the reason why this protection is offered is because of the separation of legal and beneficial ownership. So because the assets don't belong to a beneficiary, if that beneficiary is sued, well, those assets in trust can never form part of any settlement. There are obviously exceptions, so you can't create a trust for the purpose of avoiding creditors, or if there's an imminent divorce, you can't, that trust won't form part of, won't offer that protection if you could foresee the divorce, or if the trust assets have been used as part of the marital property. But there is an element of protection that it can offer, even for divorce. The avoidance of probate. So what is probate? Probate is the legal process that someone has to go through if someone passes away. It's a court process. It's extremely arduous. Because the trust doesn't form part of the deceased's estate, those assets just continue to exist and flow to the beneficiaries. They don't get frozen. They don't get tied up in probate. It can take quite a while for assets to be released. Tax planning, which is from a UK perspective, other jurisdictions might also have tax advantages if you are creating a trust. Estate planning. So again, when you create a trust, you are giving clear instructions from day one. You're still alive, so you know how it's going to work. You cannot rely on a will, which can be contested. It just gives you certainty from day one. So it's a very important tool as part of the estate planning toolkit. People often ask, should I have a trust and a will? You should always have a will. So a trust is not for everyone, but they work side by side and hand in hand, or they can work hand in hand. Business continuity, again, there's a lot that you can do with business planning and trusts. You could do employee benefits trusts. Personal shares can be put into trusts. So there's a seamless transition in the event of death. You can make sure that a business is professionally managed and that it doesn't fall into the hand of spendthrift children or family members, for example. So you can make sure that everything continues smoothly, certainly in the event of death. Political risk, you just need to be sure that you set up a trust in a jurisdiction. So if you're in a high-risk jurisdiction, you could set up your trust in a jurisdiction which offers you certainty and a robust legal system. There's an element of confidentiality that a trust offers as well. Again, if someone passes away, your will becomes a public document, whereas a trust offers a greater level of confidentiality. There's no public register of beneficiaries typically, for example. But also you can avoid forced heirships. So this might not apply to someone living in Hong Kong, but certainly someone that might come from a country where forced heirship does apply. So an Islamic state, a country, for example. So perceived disadvantages. So these are just some of the things that people say to me when they're hesitant to set up a trust. So they often say, well, look, I'm just a bit nervous because I don't want to completely lose control over my estate or over my assets. Well, there are solutions which we can offer. So to mitigate against that concern, one of these solutions would be to perhaps set up a holding company, and you can control assets through the underlying company to a certain degree. As I mentioned before, you can appoint a protector, which typically has the role of hiring and firing trustees, so it's an independent person acting for the beneficiaries of the settlor. You can reserve powers, so in Hong Kong, you can reserve investment powers to the settlor, so the settlor can control how investment decisions within the trust are made. Other offshore jurisdictions might offer the settlor a much wider array of reserve powers. So it just depends on the circumstances. You might consider a private trust company, which is essentially establishing a company which has a sole purpose of acting as trustee, which you could sit on the board of. So slightly more complex solution, but one that is available to you if you're nervous about losing too much control. Costs, it's not just for billionaires. So often you'll find that the long-term benefits outweigh the costs of setup. And we can always work with annual fees or fixed fees, rather, which far more people are comfortable with. People say it's very complex. Well, we're professionals and our job is to help you navigate that complexity, talk you through the procedures and the setup in a non-legalese, simplistic way as far as possible. Also know that trusts have been around for ages. So the laws are established and they're familiar with a lot of professionals out there. So again, we're here to help you navigate the complexity. People think trusts are high risk. So they're not really. So you should go to, although anyone can act as trustee, you should, to mitigate that risk, or there are ways to mitigate it, you should go to a professionally licensed trust and corporate service provider with a long-standing history. Your assets are ring-fenced from the trust company typically, so that they will be in their own bank account. They belong to the trust, not trust, or to the trust company. Typically, a trust company will have professional indemnity insurance, and sovereign, for example, have billions under management. So the benefits can far outweigh the costs. Now, talk about the advantages of trusts. I'm just going to go to the main real nuts and bolts of this topic, and that's the excluded property trust. So this is essentially a trust that is set up by a non-dom that contains non-UK assets. This is compared to a relevant property trust, which is a trust that might have UK assets in it and will be subject to tax. So if you look at the illustration, excluded property trust would be an overseas discretionary trust, so a Hong Kong trust, for example, with sovereign as the trustees, set up by a non-dom settlor with a variety of underlying assets. Overseas assets must be settled into the trust, so you should not put UK assets into the trust. And these assets, importantly, remain outside of the scope of IHT permanently, even if the UK or the settlor subsequently becomes UK domiciled. That's very important. So settlor can be a beneficiary and still no IHT. Care should be taken, though, if that settlor does become resident, might have to be excluded, but we can look at that on a case-by-case basis. I'll show you on the next slide how this could work for UK situs assets, but it certainly won't work for UK residential property. Sorry, before I go to the next slide. So again, this overseas discretionary trust set up by a non-dom individual, those assets will be free of UK inheritance tax. There's also deferral of income and gains. So again, you don't need to claim the remittance basis if your overseas assets are settled into trust, and you can benefit from gross roll-up. So unless you make withdrawals and you're living in the UK, they won't be subject to UK tax. The assets in the trust won't. There's no UK IHT on the settlor's demise, and yeah, it's just a very good option. There is the possibility of settling UK assets into trust, into an overseas discretionary trust, and this is how it should be done or could be done. Again, it needs to be assessed on a case-by-case basis. Basically, set up overseas trust, Hong Kong trust, set up by a non-dom, perhaps someone moving to the UK from Hong Kong. Even if the UK resident, even if there are UK residential beneficiaries, the way to hold assets though is through an overseas company. So the UK assets can be held the overseas assets can be held directly by the overseas discretionary trust. If you set up an overseas company like a BVI or a Hong Kong company, and those in turn own UK assets, then those might be shielded from UK IHT. Those UK assets cannot be residential property. This has to be done very, very carefully, and again, has to be done in conjunction with tax advice. But basically, you need to ensure that the overseas assets are in the UK assets are in the overseas company before setting up the structure, and obviously before being settled into trust. So you can't set up an overseas discretionary trust with underlying overseas company and then settle UK assets into the trust or into the underlying company. It just won't work. So I'm just going to give you a quick example of the difference in IHT treatment between someone that would have set up a offshore discretionary trust as opposed to someone with no plan that didn't do any planning at all. So we've got Mr. and Mrs. Cho, married couple, resident and domiciled in Hong Kong. Their assets include Hong Kong property, insurance policies, cash, stocks, UK residential property, UK investment property. These belong to Mr. Cho with conversions, let's call it £3.3 million. Mrs. Cho's assets include UK property worth £250,000, various investments for 2 million Hong Kong dollars, and investment funds, call it in Hong Kong, roughly £950,000. So let's call it that. So Mr. Cho moved to the UK. They're there for 15 years, which means they're both deemed domicile, and Mr. Cho dies in 16 years' time. Okay. At today's calculations, there'd be no IHT on Mr. Cho's death because he's giving everything to Mrs. Cho on his death through his will. So he wills everything to Mrs. Cho, no IHT, perfect. Mrs. Cho then passes away a year later, passing all her assets to their 2 children, right? Now remember, they're both UK domiciled, and which means that they're subject to tax on their worldwide estate. So if you total up, or if you tally up all their assets, UK and non-UK assets, you'll get just over £4 million, so £4,250,000. You can take off their nil rate band, so their tax-free allowance, which leaves £3.6 million. 40% of that 3.6 million will be paid to inheritance tax, to the HMRC, which leaves 2.8 million to their children. Fine, 40%. Now compare that to the scenario of them having settled all the non-UK assets on trust before becoming a UK resident. Let's forget about Hong Kong stamp duties and that kind of thing. So if you tally up all their offshore assets, you get basically £1.1 million. And it's really only, sorry, if you tally up all the offshore assets into trust, that leaves only their UK properties. And the 3 properties combined is £1.1 million. Only the £1.1 million that have in their names will be subject to UK inheritance tax. You can take off their combined nil rate band of £650,000. Because the overall estate is less than 2 million, what they actually have what Mrs. Cho actually has in her name when she died, she gets the additional residential, the property, the band for the marital home. So essentially, which leaves them with a tax-free allowance of £1 million and only £100,000 worth of taxable assets. 40% of that will go to inheritance tax, and which leaves £4.2 million for their children. So a significant larger amount for their children. Obviously, this doesn't take into account stamp duties, investment returns, changes to the rules, but etc. But today, this would be the effect. So there's a huge difference here, and huge savings that they could have made if they had set up an offshore trust. Is a trust for me? So speak to us if you have general concerns over succession planning, family dynamics, etc. If you have UK IHT concerns, certainly just speak to us or a tax advisor. We can work with a tax advisor on a cost-benefit analysis. Our typical trust client would have an NAV in excess of 20 million Hong Kong dollars, so around 2 million pounds, including Hong Kong and non-Hong Kong assets. So you don't have to be a dollar billionaire to consider this for yourself. A typical minimum trust settlement would be around 8 to 10 million Hong Kong dollars, so around £1 million, to kind of make it worth your while. The costs really depends on the jurisdiction that you choose, but the complexity, the size of the estate, what you're trying to and what you're trying to settle and trust, the nature of the assets. Always recommend taking separate legal and tax advice, and we can assist with that as well. The timeline or the setup timeline, you really should start early. So it does take a while for the advice to come through, and for all structures to be watertight and to be in full effect. So once all the advice is obtained, the KYC process can take around 1 or 2 weeks. So we'll need bank statements, source of wealth, source of funds, IDs, etc., references. The formation of the trust deed usually takes around 2 to 4 weeks. That's with some back and forth, explanations, amendments, whatever might be required. If a holding company is required, it might take 1 to 5 days to incorporate. That's in Hong Kong, so that's fairly quick. Bank account application will take at least 4 weeks, could take even up to 6 months. So that's a very conservative estimate, or generous estimate, I should say. Settlement of assets, it could take 4 to 12 weeks plus. So look, you're really looking at around 6 or 7 months to get everything in place. It can be done quicker, but you just want to give yourself as much time as possible. I've gone through the sovereign stuff already, so we've got in our offices. How else we can help? So we can do a number of things, either through either in-house or through one of our partners, both in Hong Kong and the UK. We can introduce you people that can help with your pre and post arrival tax evaluation, planning and advice, immigration advice. We've got partners that source schools and universities. We can obviously help you evaluate the need for any trusts and provide trustee services, assist with the UK bank account opening, sourcing real estate through our partners, registration with HMRC and customs. We can introduce you to partners to create a will, life insurance. We can obviously assist with setting up a UK company and any restructuring with your Hong Kong businesses or other overseas entities. We provide family office services, review of alternative citizenships. We've got a huge residency and citizenship program, Portugal, Gibraltar, or elsewhere, and ongoing fiscal representation and advisory for UK individuals and overseas companies when it comes to the UK. So the key takeaways, again, urgency and timeline. If you are a BNO, you're in a far better position than someone that perhaps is a UK domiciled individual, and there's far more planning that you can do. Speak to an expert, speak to them, don't rely on what you hear or read on the internet. We can help with practical solutions. You will eventually be subject to IHT if you become UK domiciled, so that's very important. And consider all your wealth succession planning trust planning, put it on your to-do list before your departure to the UK. That really is key. The more time you give yourself, the better. Let me have a look at if any questions have come through. Okay. So who would manage my brokerage accounts? Someone's asked who would manage my broker accounts. Well, you can do it yourself if you are the settlor, or you can get an investment advisor to manage it on your behalf. So it just depends on how the trust is set up. The second question is, where should I set the trust up? Look, the choice of jurisdiction is really yours. Thanks, Matt. It needs to be assessed on a case-by-case basis. People in Hong Kong might prefer to set up their trusts in Hong Kong. They're familiar with the jurisdiction, they know it. It's considered offshore from a UK perspective, or you might want to go somewhere closer to Europe if you're going to be there. So it needs to be assessed on a case-by-case basis. As I said, some jurisdictions enjoy far more reserve powers than others. So there's a lot more you could do in a truly offshore jurisdiction than you could do in a midshore jurisdiction with the trust deed. And then last one. Yeah, what is the rough price? So again, it just depends on the circumstances. You're looking at around 10 to 12,000 US dollars for that setup and the first year of annual fees included. And then your annual fees after that would be around 6,000 US. It all depends on the jurisdiction, the complexity, and where you're going to get it set up. And let's have a look. That's it. Thanks very much. I hope you enjoyed that. If you have any questions after this, just please send me an email or give me a call, or my colleague. Again, you will receive the slides, and that's it. Thanks a lot.